We're here today with Lisa Jemmeson from Jemmeson Fisher, Solicitors and Accountants. Good afternoon, Lisa. How are you?
Good afternoon. Very well, thank you.
Well, we're in a very interesting subject here. We're going to talk about leases, but more importantly, the special conditions that agents can put in leases and what they shouldn't put in leases. So, what do you think?
Well, I think it is a very interesting topic, as you said, because some agents really go to the extreme and put some very weird and wonderful things in their special conditions. And so I think what we'll do is we'll just review what's allowed and what's not allowed. So our starting position will be that the lease document is prescribed. So it's a prescribed document in the regulations, and the Tenancy Act allows under Section 15 for a standard agreement. So you start with that, and the standard agreement's pretty good. It covers the areas that protect the rights and obligations of landlords and tenants. So there shouldn't be too much that you need to put into a special condition. Now, having said that, tribunal members often see, like I say, some very weird and wonderful special conditions, so that when the regulators were preparing the Tenancy Act, they felt it necessary to put some conditions in relation to these special conditions. And the first one is in relation to prohibited terms, and this falls under Section 19. And this covers the mandatory carpet cleaning term that was often put into leases, so that when a tenant vacates, they must have the carpets steam cleaned or dry cleaned. That's out. Next one is in relation to insurance. So they may put in there that you as a tenant have to make sure that you insure all your own goods to the extent in relation to insurance that you have to indemnify the landlord's agent against any claim that you have against the landlord. All that is out. You can't have that in there. Any penalties. If you pay your rent late, we're going to charge you an extra 5%. And you might see these in commercial or retail leases. You certainly cannot have them in residential leases, so they're definitely out. You can't mandate that a tenant has to use a specific tradesperson. They might be for trimming lawns or whatnot. So we have this regulated in Section 19 as prohibited terms. Then in Section 21, the Act goes on to talk about inconsistent and terms that are void. And if you do have a special condition in your lease, so for example, you must use XYZ lawn mowing to come and mow your lawns every fortnight, the tribunal can strike that term out. It doesn't invalidate the whole lease, but they can actually take that out, which is good. You can't have anything that's inconsistent with what's in your standard lease, going back to that Section 15. Now under Section 22, it's an offence to include prohibited terms. And that should be of interest to estate agents, in that if you go before the tribunal and you fail the attitude test and a tribunal member takes a particular dislike to you, then potentially there's the opportunity to either refer it to fair trading or for further action to be taken, because you as an agent and licensed agency should not be putting these terms into your leases.
So what terms can you put into your leases?
Right. Well, in view of the fact that it is a complete document, the Tenancy Act, there are certain terms that you can put in that the tribunal themselves have looked at and have okayed. Now, I just want to put one qualifier on it. If it goes before a tribunal, then the decision isn't binding on other tribunal decisions nor other members. Okay, it can be persuasive, but it doesn't necessarily mean that it's binding. So any that we mention from here on in, you don't come with a guarantee that you will get these through. If you want a guarantee, you go to Kmart and buy a toast, as we say. Okay, so the first one is that we often see in the special conditions, if you get an inflatable pool, you can't put that up in the residential property. So a lot of people will go to children's stores and buy little inflatable pools, not the shell ones, but bigger ones with a pool filter. Won't comply with, we were talking about swimming pool compliance a little bit earlier with Greg, you were, won't comply with fencing requirements, that a tenant cannot put that type of pool up. Second one might be in relation to smoking. And this one has come before the tribunal in relation to smoking inside, and the tribunal has upheld a landlord's claim for dry cleaning of curtains and dry cleaning of carpets because of the nicotine effect of smoking inside. So there's an example of one that has been allowed. Tradesperson's hours. So for non-urgent repairs, if an agent puts in that our tradespeople will attend between normal business hours of 9 to 5, Monday to Friday, this can be allowed for non-urgent repairs. In relation to pets, so currently it's standard in a lease that there are no pets allowed on the premises. However, in the special conditions you can allow a pet, and then you have the option to say that either the carpets have to be professionally cleaned at the end of the tenancy, or fumigation has to be completed at the end of the tenancy. Now, a lot of agents are electing to have fumigation where they're allowing pets, and then relying on ordinary terms of if the carpet is dirty in relation to cleaning of carpets. So that might be a wiser choice for agents. And the final one that's allowed and approved is in relation to the break fee. So if a tenant is breaking their fixed term lease, so currently for a tenancy that's 3 years or less, if you're not through the first half of that lease, then you can claim a 6-week break fee. If you're in the balance, the final half of your lease, then you're down to 4 weeks. If the term of the residential tenancy agreement is over 3 years, you can actually specify what the break fee is going to be. If you don't nominate the break fee, then you go back to how it was in the previous legislation, where you pay rent up until the time I find a new tenant, and you pay the reletting fee and any associated costs. So you've got to nominate one or the other in the tenancy agreement. Some examples that you could not put into your special conditions relate to insurance, as we touched on before, requiring tenants to have their own contents insurance. There is a consumer guide produced by Fair Trading that advises them that they should, but you can't tell them to go and take insurance. Access in relation to keys, so a special condition saying if we need to come in for periodical inspections or tradespeople, you authorise us to use our keys. That one's out. Rent being further ahead than the 2 weeks in advance, so saying that you must be 6 weeks ahead at all time, that's definitely out. Pet bonds is another one, that's out. You can't have a separate pet bond. Refurbishment clauses, when the tenant vacates you must repaint the house, that one's out. And any sort of contracting out, so anything that says, for example, separate metering. We don't have separate water or flow meters on the property, but the tenant agrees just to pay half the water bill. Those types of things are definitely out.
Well, Lisa, that is excellent. I mean, that really helps agents to decide what they can and can't put in their lease and their special conditions. We thank you very much for all that information today.
My pleasure.